What protection do I have if I go on strike? If conditions at work become unbearable, low wages, unsafe practices, unfair treatment, workers sometimes decide the only way forward is to strike. But here's the big question. What legal protections do we actually have if we go on strike? Can we be fired? Can we be replaced? Do we get our jobs back afterward? The answers depend on the type of strike, the laws that govern it, and how the employer responds. Under the National Labor Relations Act, striking is a protected right, but not all strikes are treated equally. Some give workers strong protections, while others leave room for replacement or delay in returning to work. In this video, we'll break down the rules. We'll explain the difference between economic strikes and unfair labor practice strikes, what protections apply, real-world examples, and what workers can do to stay within the law. 1. Section 7. The legal right to strike. The foundation is Section 7 of the N.L.R.A. It states that employees have the right to engage in concerted activities for mutual aid or protection, which includes the right to strike. That means, in general, workers cannot be fired simply for going on a lawful strike. Striking is recognized as a core tool of collective bargaining. Without it, workers would have little leverage against employers. But here's the nuance. While striking is protected, the outcome, whether we keep our jobs, whether we can be replaced, and whether we get reinstated, depends on the strike's purpose. So Part 1 establishes the baseline. Yes, we have the right to strike, but protections vary depending on circumstances. 2. Economic strikes versus unfair labor practice strikes. There are two main types of strikes under U.S. law. Economic strikes. These happen when workers walk out to demand higher wages, better benefits, or improved conditions. They are lawful, but employers have the right to hire permanent replacements. Strikers cannot be fired, but they may not get their jobs back right away if replacements are hired. Unfair labor practice, ULP, strikes. These happen when workers strike because the employer has violated labor law, for example, refusing to bargain in good faith, retaliating against union activity, or committing safety violations. In ULP strikes, workers have stronger protections. They cannot be permanently replaced and must be reinstated when the strike ends. Example, if workers strike for a $2 wage increase, that's economic. The company can legally hire replacements. But if workers strike because management refuses to negotiate at all, that's a ULP strike, and the strikers are entitled to reinstatement. So, Part 2 makes it clear. The type of strike determines the level of protection. 3. Replacement, reinstatement, and pay. One of the biggest fears workers have is, if I strike, will I lose my job? The answer is no. You cannot be legally fired for striking. But in economic strikes, employers may hire permanent replacements. If that happens, strikers are placed on a recall list. They have a right to return when openings appear, but it may take time. In ULP strikes, replacements cannot be permanent. Strikers must be reinstated once the strike ends, even if replacements were hired. As for pay, employers are not required to pay workers during a strike. Strikers may rely on union strike funds, savings, or community support. In some states, workers may qualify for unemployment benefits during a strike, but this varies. Example: airline mechanics strike for higher pay. The airline hires replacements. Strikers keep legal protections but may wait months before being recalled. By contrast, if they struck because the airline refused to bargain, reinstatement would be immediate. So Part 3 explains the critical difference between being replaced and being fired, and why the strike's purpose matters. 4. Limits on the right to strike. Not every strike is protected. Certain actions can strip away legal protections. Violent strikes. If strikers engage in violence, threats, or property damage, protections may be lost. Partial or intermittent strikes. On-again, off-again strikes, where workers repeatedly stop and start, may not be protected. Sit-down strikes. Occupying the workplace instead of leaving can be deemed trespassing. Strikes in certain industries. Public employees, like police or firefighters, may be restricted by state law. Airlines and railroads follow the Railway Labor Act with stricter procedures. Example: factory workers strike peacefully outside the gates. They are protected. But if they occupy the plant, block entrances, or damage property, they risk losing N.L.R.A. protection. So Part 4 makes it clear. Striking is a right, but it must be exercised lawfully to keep protections. 5. Real-world examples. Case 1. N.L.R.A v. Mackay Radio, 1938. The Supreme Court ruled employers can hire permanent replacements during economic strikes, establishing the rule that still applies today. Case 2. Nurses strike. Nurses walked out over unsafe staffing levels. The N.L.R.A ruled it was an unfair labor practice strike because management ignored safety complaints. The nurses were reinstated immediately. Case 3. UAW auto workers. Strikes for better wages led to temporary replacements. Strikers were recalled as positions opened, but some waited months. Case 4. Teacher strikes. In some states, public school teachers striking faced fines and discipline, showing how state laws can limit rights outside the N.L.R.A. These cases show that the line between economic and ULP strikes shapes the outcome dramatically. 6. What workers can do to protect themselves. If workers are considering a strike, there are steps to maximize protection. Work through a union. Strikes organized through unions are more likely to comply with legal rules. Give notice when required. In healthcare institutions, the N.L.R.A requires at least 10 days' notice before striking. Stay peaceful. Violence or threats can erase legal protections. Know the goal. Framing the strike as a response to unfair labor practices strengthens reinstatement rights. Document employer violations. If management refuses to bargain or retaliates, that evidence supports a ULP strike. Example: hotel workers strike over both wages and retaliation against union leaders. If documented properly, the strike may qualify as a ULP strike, giving stronger job protections. So Part 6 shows workers are not powerless. They can take steps to ensure the strike is legally protected. 7. Why the right to strike matters. The right to strike has shaped American labor history. From coal miners in the 1930s to fast food workers today, strikes have won safer workplaces, shorter hours, and better pay. Without the ability to withhold labor, workers would have little bargaining power. But the law tries to balance worker rights with employer interests. That's why economic strikes allow replacements, while unfair labor practice strikes offer stronger protections. The system encourages both sides to resolve disputes through negotiation while still protecting the core right to strike. So the bigger picture is this: strikes remain one of the most powerful tools workers have, and knowing the rules makes them even stronger. So, what protection do we have if we go on strike? The answer is a lot, but it depends on the type of strike. Under the N.L.R.A, striking is a protected right. In economic strikes, workers can be replaced but not fired. In unfair labor practice strikes, workers must be reinstated. Either way, violence or misconduct can strip away protection, and public employees may face separate rules. The key is knowing the law, working together, and keeping the strike lawful. Strikes are powerful, but their protections come from staying within legal boundaries. If this video helped explain your rights, share it with coworkers. The more we know, the better prepared we are to use our rights and protect ourselves at work.